Additionally, there's some argument that the government and the petitioner make that this is really not a problem, kind of what are we doing here? But Judge Rosenbaum in the 11th Circuit observed that in the 3 months after this court's decision in Welch, the 11th Circuit saw 1,800 applications for Johnson-based review. So I do think it is a real problem that courts are grappling with. And the tools that Congress gave the courts of appeals to deal with this problem allowed it to make the expeditious determination under the 30-day clock. And what petitioner and the government would say is, well, we're going to take one of those key tools out of their tool belt. We're not going to allow them to look and see, was this argument already presented? And if so, can we dismiss it on that basis alone? And that makes it more difficult to accomplish its task in 30 days. I think one thing is significant about that also is Congress provided the same 30-day clock for state prisoners and federal prisoners. It didn't say we're going to give 30 days for state prisoners and 45 for federal, or some other indication that they intended to treat them differently. And Justice Thomas, to your question to the petitioner, all indications by use of legislating by cross-reference is that Congress wanted to treat, at least for successive applications, state prisoners and federal prisoners alike. That's why they chose this kind of clunky mechanism to do so via cross-reference. One additional point, petitioner, in response to one of the questions about jurisdiction, said that there's a clear statement rule as it relates to state prisoners with the jurisdictional point because of the word application in 3E. That's significant because that is saying that is a clear statement that this applies to state prisoners, which is exactly our point. Every time Congress said application, it was excluding on its face federal motions. So in order to read any of these provisions as applying to federal motions under 2255, you have to view them in light of the cross-reference. And that's exactly what you do when you look at 3C's cross-reference to B1. You read that language, a successive habeas corpus application under 2254, in light of that cross-reference to apply to similarly situated federal prisoners. And again, Justice Gorsuch, to your question, it's not like it says applications by Guantanamo detainees. I think my argument would be harder if the additional language was something that didn't map on so tightly to the 2255 mechanism, but instead that's a closer fit than the application language that the government and petitioner rely on to bring in the certification provisions in the first place.
Which can include pre-conviction detainees.
Yes, Your Honor.
Yeah.
And so it's just a natural fit to see what Congress was doing there. Again, in the wake of Oklahoma City, there's no reason to think that the #1 finality provision in 2244, which was titled Finality of Determinations, that they intended that not to apply to federal prisoners like McVeigh, which was the exact target of the 1-year anniversary when President Clinton signed this bill into law.
Implicit repeal of a power federal courts had previously to prevent do-over petitions by federal habeas petitioners.
Exactly. And instead, they rooted them through the provisions for 22, provisions that otherwise applied to state prisoners. And one important point, the standalone language that prevented successive applications by federal prisoners had long been marginalized by this court. In Sanders, the court said, this can't be taken seriously. And so it's perfectly natural for Congress to say, you didn't do what we said in 2255, and instead this time around, we're going to put you in the same bucket as state prisoners where you will enforce the successive bar. And the combination of B1 together with subsection 1 and 2 in 2255 addressed both the successive and the abuse of the writ problems that Congress was targeting in EDPA.